Andrew, can you tell me some more about mediation in a personal injury case?
Sure, Krista. Let's talk about, well, it's mediation, but it falls under the umbrella category of alternative dispute resolution. Now, what does that mean? Or ADR for short. Probably, I'd say 30 years ago, maybe 35 years ago, uh, the courts became obsessed with the concept of let's get the cases out of the jury trial system, which is clogging up the court, and instead force everybody to go to alternative dispute resolution. Now, alternative dispute resolution can take a couple of different forms. It can be arbitration, which in the last 10 years or so has become almost ubiquitous in every commercial agreement that people sign. They agree to arbitrate rather than take the case to the courthouse. The other type of frequently used alternative dispute resolution is mediation. And we're going to talk about mediation today because, at least in the state of Florida, mediation has become in effect, a de facto requirement in every case that you may file at the courthouse, which involves any kind of lawsuit. So I want to talk about what mediation is and what someone could expect when they're sent to mediation. And basically, mediation is a key step in resolving a personal injury claim before trial. Okay. And it's a structured but informal negotiation process where both sides work toward a settlement with the help of a neutral third party called a mediator. Now, in Florida, most mediators, especially in any significant lawsuits, are certified by the Florida Supreme Court. Uh, in addition to being a board certified trial lawyer, I'm also certified as a circuit court mediator in the state of Florida. Circuit court is our trial court of general jurisdiction, meaning that all significant lawsuits have to get filed in circuit court first in the state system. Now, the purpose of mediation is to reach a fair settlement for both sides without the risks, costs, and delays of a trial. In mediation is the only opportunity that a plaintiff, an injured person in a personal injury case, has to control the outcome of their lawsuit. If you don't have mediation, and you don't settle outside of the mediation process, which is still a possibility. That's very old school. Lawyers used to do that all the time before mediation became in vogue. And you can still do it, but mediation is more frequently the source of settlements these days. You have control over what's going to happen in your case. If your case goes to the courthouse, you're going to be in front of a jury if you have a jury trial. Which is most frequently what happens. Occasionally, personal injury cases go in front of circuit court judges and they decide it on their own, but most personal injury cases go in front of a jury. Now, a jury in Florida consists of 6 people selected at random at the courthouse that your lawyer would be able to question about their particular biases and prejudices, and hope that you get 6 people that are going to be sympathetic to your cause. But, okay, you don't have control over what they do. And so all kinds of crazy things can happen. There are cases that you can go to trial on that you're absolutely certain that you're going to win and you wind up losing. There are cases that you go to trial on that you're certain that you really have very long odds against winning, but you wind up winning. But you don't have control. It's very random. It's I don't want to call it a lottery because that's almost pejorative, but it's an outcome that you have no control over. 6 strangers that know nothing about you. They only know what is told to them by the lawyers in the case, which very often is filtered through the judge, and they're making a decision. But in mediation, okay, you're making the decision. You're evaluating what the offer is, and you're going back and forth with a mediator who will be suggesting to the other side what the shortcomings may be in their case and why they might want to add more money. Likewise, they'll be sitting in a room with you and they'll be explaining to you what the shortcomings of your case may be and why you should compromise off of the amount that you're requesting as settlement. So it allows you to have a say in the direction that your settlement is going in. And that is the only way that you get some control over the outcome of your case. Now, what does the mediator do? Okay, the mediator is a neutral. The mediator doesn't make decisions for you. The mediator doesn't tell you what your case is worth. The mediator doesn't suggest how much your case is worth or whether you're going to win or lose. A mediator is a neutral. He doesn't make decisions. He just facilitates discussions. And a good mediator will help you understand and gently direct you toward a compromise that ideally is fair, okay, but they cannot make the decision for you. They can't force a settlement on you. And if both parties agree, sometimes the mediator can make a suggestion about the amount that they think the case might be worth. It's very rare, okay, but it can be done, okay. Sometimes it's referred to as the mediator's silver bullet when two parties get close enough to get the case resolved, and the mediator's suggestion or the mediator's silver bullet may be the way that you finally get the case over the goal line and get it settled. Now, everything that you discuss during mediation is confidential. It can't be used in court, and anybody who participates in the mediation process is bound by that confidentiality. It also means that you can't talk about it with your family members unless they're part of the mediation, or with anybody else who is not subject to the mediation confidentiality privilege. Now, the reason why we do it this way is because we want to have open discussions without fear of it being held against us. And you don't want the other side coming into the courtroom and telling the judge, Judge, they were willing to take X number of dollars to settle the case in mediation, and now they're asking for twice that much. No, the judge doesn't hear any of that, and you're not allowed to say things like that. What goes on in the mediation conference stays in the mediation conference. Now, mediation has changed a lot because of the paradigm shift affected by the pandemic. Because of the pandemic, we couldn't meet in a conference room where everybody was on top of each other and potentially infecting each other during the pandemic. So they came up with a way to do it virtually. And it's done most commonly on the Zoom platform. And on the Zoom platform, everybody appears on the screen, and the mediator is able to create what are called breakout rooms, meaning that you come up with a virtual conference room apart from where everybody else is, and that conference room is confidential. And the only people who enter that virtual breakout room or conference room is the mediator, your lawyer, and yourself or any other parties that you may have brought to the mediation. The mediator will go back and forth between these breakout rooms and describe to the other side what's going on and what the counteroffer may be. And in that way, you have communication, but not having to sit in an actual room. Now, the same thing is true with clients and their lawyers. While your lawyer can have you in their conference room at their office, most frequently, the client is actually in their home or their own office, and your attorney is in their office. And again, you're connected virtually on the Zoom platform, and that's the way you go back and forth. Now, before you get to mediation, your attorney will have sent a mediation summary to the mediator describing the facts of the case and your view of it. Both sides will submit mediation summaries. The mediation summaries are generally considered confidential, although some mediators like to share them. So it's always a good idea for your lawyer to make sure that it's clear in the mediation summary itself that it's intended to be confidential or it's intended to be shared. I usually always just send them confidentially. Now, your lawyer before the mediation is going to have gotten a handle on what your case costs may have been. They will have reviewed your medical records so they can describe all your medical problems as well as the facts of the case to the other side. And your lawyer will also probably have evaluated what similar cases may have settled for if that information is available. The more data points you can establish on settlement, the better off you'll be because your lawyer will be able to guide you as far as they're in the ballpark when you get an offer. Now, in that mediation, you generally will have a representative from the insurance company or risk management if it's a medical malpractice case against the hospital, your lawyer, and you or family members if they choose to be there with you. In this mediation, it usually starts out with the mediator making a short opening statement telling everybody what it is that they're getting into and what mediation is, and explaining that the mediator doesn't make decisions for them. It's up to the parties to be self-directed as far as whether the case settles or not. After the mediator gives that initial little speech about what mediation is, each party will have an opportunity to briefly describe what the case is about in their view. Depending on the circumstances, your lawyer may want to make a more elaborate presentation or may choose to make no presentation at all. Sometimes emotions are so high in these mediations that making a statement only cements people's positions more than they were before. So your lawyer will have to judge whether a mediation statement is necessary, and if so, to what extent he or she may choose to describe what your case is about. You'll also have made, or your lawyer will have made, a settlement demand. And that settlement demand will be the beginning of your bargaining position. It's generally quite a bit more than where you want to wind up because you're going to be negotiating back and forth. Now, what can you expect? Okay. After that initial series of statements back and forth, and by the way, you don't have to say anything in mediation. Your lawyer may want you to make a statement, but you don't have to answer any questions. Okay. Nobody's going to ask you questions that you have to answer. You can just sit there and you can listen. Okay. So after the opening statements are done, the mediator will break up into what they call caucuses, which are just putting the various parties into the breakout rooms that we described a few minutes ago, those virtual breakout rooms. And the mediator will then decide whether they want to speak to you first or speak to the other side first. And it really just depends on the case. The mediator will get additional information if need be, and also feel the temperature of the room, as they say. Now, it's virtual, so you don't really get that, but by the comments that you make, the attitude that you're demonstrating virtually, the mediator will get a feel for how committed you are to a particular position. Okay, so once the mediator has gotten that offer to settle or demand to settle, they'll go back and forth until the gap is bridged. If the gap doesn't get bridged, then your case will not resolve in mediation. It will reach something called an impasse. The mediator can declare an impasse at any time. That's one of the options that they have. The other option is simply to continue the mediation. The mediation will then be ongoing, and the mediator will probably get in touch with the parties after you all leave there, going back and forth again as if you were still in those breakout rooms. But the mediation is not concluded. At the conclusion of the mediator will usually file something with the court advising that mediation has occurred, because one of the pretrial requirements in almost every case in the state of Florida is that there be mediation. So the mediation statement from the mediator tells the court that, yes, you mediated the case, so you've complied with that court requirement. If the case doesn't settle, then you wind up going to trial whenever that may be. And one of the advantages of mediation, of course, is that you get the case settled, you have closure, and you also have the settlement proceeds available to you in a very short period of time, usually 30 to 60 days, and you don't have to wait years for to see the money, which would be the case if you had to go to trial, have a trial. Depending on the outcome, there may be an appeal, and that can go on for 2, 3 years or more. So you do get resolution much more expeditiously. And there are people who have genuine needs in their lives, and so they need that kind of closure. Now, once you've reached an agreement in mediation, though, you're going to be asked to sign or virtually sign a mediation agreement. Okay, that's binding, it's legally binding and enforceable. It's a settlement agreement. And that settlement agreement will dictate the conditions under which your case has been settled. Now, don't be surprised in a mediation if the opposing side, if you're making the demand, if you're the injured person, comes in with a low ball offer to start with. You've come in with a high ball offer. So you're going to negotiate back and forth. Don't be offended by that low ball. Just go back and forth. And depending on how the negotiations are going, your lawyer should be able to judge what are the appropriate moves that should be made as far as reducing your demand and getting toward that middle ground where the case should settle. And there are different techniques that the mediator may use to try and move everyone toward that middle ground where you can reach some consensus and your case will get settled. Now, you should expect that, especially in a large case, that you're going to be there for several hours. Okay. And as I said before, sometimes mediations don't conclude in a single day and they get continued for either another session or for the mediator to continue working behind the scenes the way I described a moment ago. Now, this can be emotional, okay? And one of the things that your lawyer should try and do is try and take the emotion out and make it clear, okay, that the decision that's being made can't be based on emotion. It has to be based on objective facts. If emotion is going to drive the proceedings, the likelihood of a successful outcome is probably diminished quite a bit. So that's kind of an overview of what mediation is and what you can expect. And just to sum it all up, the advantages are you've got a faster resolution. It's going to cost you less because you're not going to have the cost of preparing for trial and the cost of trial, which can multiply your pre-trial costs easily by a factor of 3. It's going to be less stressful because you won't have to sit in a courtroom for a week or 2 weeks or a month, okay, waiting for those 6 strangers to make a decision about your life, okay, and you have control, therefore, in the mediation over the outcome, okay. You decide the terms, not the judge, not the jury, okay. So that basically sums it all up. And expect that if you have a personal injury case in the state of Florida, at some point you're going to be directed to mediation. And this is pretty much what you can expect once you're there. Thank you.